Yes, I do. I was never thinking otherwise. If I could have your attention, please. Good evening. My name is Michael Hunter Schwartz, and I'm the Dean of the McGeorge School of Law, and I welcome you to our gorgeous campus. For those of you who aren't here as often, I also celebrate our students, some of whom are here to support one of their peers and friends, so I'm very grateful for that. As most of you know, this is now the fourth of our 100th anniversary events, and it has been a whirlwind and amazing. Perhaps we wouldn't have scheduled two events back to back, the Ninth Circuit yesterday, and then today, this event, but actually we also grafted on our legislative leaders event with our alumna, Angelique Ashby. So it's just because we're such an awesome law school. And so can't help that. So my only job as dean is that I get to introduce Judge Callahan. And so I tried to go with like the standard stuff, and then I mixed in some interesting facts that she doesn't know that I'm going to be sharing. Judge Callahan began serving on the Ninth Circuit in 2003. She was confirmed by a 99-0 vote. No one votes against Judge Callahan. Here's the first of the interesting trivial facts. This is not so trivial. In 2005, according to numerous reports, she was one of two finalists to be appointed to the United States Supreme Court. Yes, she's never told me that. Can you believe that? Thought we were friends. Before she was on the Ninth Circuit, she was on the Third District Court of Appeals, started there in 1996. Before that, on the Superior Court, 1992. First appointed to a bench role in 1986. One of my favorite things, and this is my second fact she didn't know that I was going to pull, is on the California court's website, they still have a bio for her, and the bio starts out by describing her as stylish and vivacious, which is something anyone who spent 30 seconds with her knows is the case. She got her BA in English with honors from Stanford University. In 1972, she graduated from McGeorge in 1975. She got an LLM from UVA Law in 2004. She won the Ninth Circuit Professionalism Award, and she has an Inn of Court named for her in San Joaquin County, because she's that fancy. And so I guess the last thing I will tell you is on a more sort of the experience of working with her, which is it's always educational. It always moves super fast. You cannot have low energy or you're in trouble. And she is as good a supporter of your law school as I could possibly imagine. Please join me in welcoming Judge Callahan.
Thank you, Dean. Well, the reason I didn't tell you about 2005 is I'm obviously not on the Supreme Court. So, you know, for all of the things I have gotten in my life, there's certain things I didn't get. And so we still need to get one of you law students on the Supreme Court. So I'm sorry I couldn't carry the torch for that. And I think that ship may have sailed, but we still have hope out here. And we have two young women in the front here that are in 6th grade and sophomore in high school. So I'm telling you, you got to carry the torch here. Anyway, welcome everyone. I think we have an all-star panel here today, and you have their bios, so I'm not going to go over everything because you have them in front of you, and I want to save time for the discussion. I think we have a superstar panel here. We have a law student, we have a practicing attorney, we have a trial judge, and then we have a trial judge who became an appellate justice. So we're going to talk about civility here, and so I think we've composed the panel in a way to bring you diversity of experience, of practice, and of views. You've also got great materials on the website that I think are all very, can be very helpful, and you can look at those at another time if you haven't. I will refer to the panelists formally, and we talked before, and look at how nice my law student cleaned up here. He's so pretty. I mean, we all talked about what we were going to wear and all of that, and because he was on one of our practice Zooms with like kind of a hoodie and the whole thing, and I said, "Oh, you're not going to show up like that, are you?" And he says, "Oh, no. And look at that. Yeah, I like that." So. I will refer to everyone formally, but since I know everyone, I might lapse into first names, and I mean no disrespect by that. We're going to speak about civility and incivility as they see it, and in their current positions and throughout their careers. Obviously, we're going to have the perspective of how law students feel and what they're struggling with at the time, and tie that in with everything else. But while civility probably at its core surely has a meaning, but it's one of those things that it can have different meanings to different people. And so that's what can make it interesting, because it can be involved with the lens that we see things through. Something that I might think is civil, you may not think is civil. And so we're going to go through this, and we're going to talk about behaviors, we're going to talk about comments that people may make, or subject that can be subject to different interpretations. As advocates, as individuals, as judges, there are certainly relevant rules that we're going to talk about, but facts do matter, context does matter. We are entering, I'm going to say at this point, and I see some of my students from Salzburg where I taught free speech, we're entering into the free speech zone here. And what I say by that is our panels, they're going to give you their perspectives. And I'm going to moderate this panel, and there will be time for questions at the end. So you will undoubtedly hear things, views, points that you don't agree with, or it may not agree with your experiences. But different viewpoints alone, does not necessarily rise to incivility. But we're human beings, and when people don't agree with us and they say things that we find very offensive, it's easy to say that they're not being civil. But the discussion needs to go deeper than that. And so I think we can choose to listen. We can choose to be offended when someone doesn't agree with us, or we can choose to listen to their viewpoints. And so I hope in this situation that we're all going to choose to listen, and that we're going to feel comfortable in expressing our views, and expressing them, even if they are different, expressing them in a tone that I, as a judge, wouldn't have to hold you in contempt. And so probably no yelling, probably no swearing, no name calling, but certainly the viewpoint can be one that we may not all agree on. So looking right here at my all-star panel, I'll just tell you a little bit about everyone. And closest to me is Mr. Ferguson, Khalil Ferguson. And he's a law student, but he's already burning it up as a top Black change maker by the Sacramento Bee's Equity Lab, and a 2021 Rockwood Leadership Building Power Fellow. He brings a racial equity lens to his leadership, as well as a passion to implement racial equity in his organization's network and community. I think he previously he's worked before he came to law school, so he's got some experience there. But he's yet to be a lawyer, so he's going to listen to all of these things here. And he's dipped his toe into politics as secretary for the Democratic Party's Black Caucus Legislative Committee, and a facilitator of the Delcy Woods Jones Public Policy. So we're really excited, and I know that those of you that know Mr. Ferguson know that he's a leader on this campus. He's a leader in thought, and he's a leader in trying to build, I think, a community where people feel that they can express themselves, but can be prepared to be good lawyers. Next on my panel Well, see, I'm going to jump to, next is Mr. Rivera, Mr. Jesse Rivera. And I often refer to Mr. Rivera and I as OGs. We're the original gangsters. We've known each other forever. We've been around forever. And I will say about one of the things about Mr. Rivera that before anyone had even heard the terms DEI, he was out there working in community groups to create diversity in the community. And he is a McGeorge graduate, as I am a McGeorge graduate. There's only one of us in this group, and I don't know if you can spot that person that went to another school, but it will come up. Oh, I guess she's identified herself. But anyway, Mr. Rivera has, he started out his career doing a lot of trials, working as a deputy public defender, and tried many, many criminal cases, then was with Porter Scott doing civil cases, and then he's been in private practice, and he's tried numerous cases, and I think he brings particularly, he's tried cases both in the trial courts, in the appellate courts, but he's a member of a very prestigious organization called ABOTA, American Board of Trial Advocates, and they are a very important organization that works on civility, and I think that he epitomizes it, but he also brings that perspective to it, and so I'm so happy that he's here with us. Then we have another McGeorge graduate, and that would be Judge Flores, and he is not as much of an OG as Jesse and I are. However, he's served in the military. He has done many things in the community, and he's a San Francisco Superior Court judge, and something that I think is really interesting is he ran for election, and that's something I've always hoped not to do. And every time when I was a state judge, my name had to appear on the ballot, but I never had anyone run against me, or you either had to vote yes or no. And then later I became a federal judge, and as long I can keep that job is for life and in good behavior. So it's really it's quite an accomplishment to run for election. And I think interestingly, he got heavy support from the Democratic, the Green Party, and the Republican Party. So that's pulling a lot together. That's my 99 to nothing there. So I think that is excellent. And he remains very active in his community and has been very involved in working to have diversity in the community on the bench and creating opportunities for others. Lastly, we have Justice Stacey Boulware-Urey, who, despite not having graduated from McGeorge, has had a very excellent career and is one of our best judges in this community. She served as a trial judge and is now fairly recently a member of the 3rd District Court of Appeal, my prior court, and serving very admirably on that. She's won many awards. She's been judge of this, judge of the year of this, that, and everything. So her awards are too many to be mentioned, but she's served on committees such as been on the Judicial Council, which is a really important, judging is self-governing, and they are the governing body. And you'll see that some of the rules that we'll talk about will be rules that are passed by the Supreme Court and will have worked their way through the Judicial Council. So we're so happy to have you here, and you're holding up the flag for UC Davis King Law. And I want to say before I came here, in honor of you this afternoon, I drank out of a King Hall mug to get in the. I know I have a lot of McGeorge mugs, but I do have a King Hall one, and occasionally I've been known to traverse here. So we've got a construct here, but I think there are rules, and you start out the first time you take an oath, right after you pass the bar, when you're happy enough to pass the bar. The oath that has been added, and it was augmented after many of us in this room when we took our first oath. This was not a part of it. But as an officer of the court, I will strive to conduct myself at all times with dignity, courtesy, and integrity. So we start with taking an oath as a lawyer that civility is recognizing that is important as part of it. There is also, and I'm sure my panelists may come up with this, and it's included in your materials, another rule It's 8.3, reporting professional misconduct, and also known as the snitch rule, okay? And that was approved by the Supreme Court effective August 1st of 23, and requires the reporting of misconduct. And arguably, like all good rules and all good legislation or laws, there's always some vagary in it, and to what extent civility would come in, and in terms of reporting, there's an area in there where that may happen. So you have your First Amendment rights, and I hope everyone will speak, but just because you have the right to say something doesn't always mean it's the right thing to say. And I've learned that in my life. I've said many a thing that I thought I had the right to say and was really smart, but the person wasn't actually that happy to hear about it. But on the other hand, we're going to start here with Mr. Ferguson. And I'd like to start with telling our audience, and what are law students concerned about in terms of what are the issues you have to deal with in terms of civility?
Yeah, thank you, Judge Callahan. That's a great question. I think in law school, I was thinking about my comments earlier, and in law school, I think it's very unique in that it's a concentration of a multiple number of feelings, stress, anxiety, political ideology, your personal identification, your personal ideology, and that becomes kind of exacerbated and comes forefront in law school. So what results in that as it relates to the First Amendment and how we conduct ourselves with civility on campus is that stress becomes tension in the classroom and on campus. And McGeorge does a great job at it, I believe, relative to other law schools, but I'm biased, clearly. But as it relates to having disagreements between, let's just start with political ideologies and how you engage with that on campus and how your personal identity reflects that in classroom, and whether you feel like something that was said on campus or in the classroom with regards to a professor reading the text or a professor reading from a statute that has been enshrined and maybe not amended since the 1700s or 1800s and refers to language that offends you, or a classmate raises a point in class that is contrary to your belief or contrary to what you think and may offend you as well. And that's, the surface level of what happens in law school with regard to the first instance of tension. Then we go to the roots and some of the subtleties under that, in that how do you engage with your law students who you don't agree with, either in a club or via email communications or outside of campus, and remembering that, Judge Callahan, you mentioned the oath that attorneys take, but I'm not sure if other law schools do it, but McGeorge requires us as a part of our pinning ceremony and one of our first assignments in GLS 1 to have an oath of professionalism. That's curated by every cohort as well. So that oath of professionalism kind of sets the standard for how we conduct ourselves on campus as students, which is supposed to transcend and eventually turn into that oath of, the oath the attorneys take, and eventually as a judge as well, if you become that. So modeling after that oath and the oath of professionalism that students strive to take, should really guide how we act and conduct ourselves with cordiality with our fellow students in and outside of the classroom. And I think that's a tough balancing act that law students right now are facing.
Well, and I think you're right, and we're going to come back to you at the end, and I'm hoping that our other panelists will comment back and forth on how, because you're looking to how to model yourself when you go to court, when you practice with other lawyers, when you call people on the phone, and there are different issues that will come up. But I think one thing that distinctly, and I will say this, and I think that this is law in the sense that it hasn't really happened at McGeorge, but I taught it when I taught free speech in Salzburg this last year, is, we've had situations at other campuses where students have shouted down speakers, and pretty much the law doesn't allow that sort of expression. You can't silence other people's speech by shouting them down. The answer to that, the answer to speech that you don't like under the law is more speech, and there can be lawful ways that you can protest or do all of those things. But the reason I mention that for students as well, and if you get arrested, it's kind of is hard to take the bar sometimes in terms of, so if you're going to exercise your rights, you want to make sure that you carefully exercise them and you exercise within the law. Now, I can't say, our dean here is one of the top 9, they have the top 20 legal educators in the country, and we're really lucky to have our dean here. He's number 9. But number 1 is Dean Chemerinsky at Berkeley, and he talks a lot about free speech. And with the protests that have been going on, with the October 6th Israeli situation and Palestinian protests, they've had a lot of those on campuses as far as that goes. And Dean Chemerinsky writes a lot about this, and he is a legal scholar in this area, and he's Jewish. And he's been having to talk to his students from this standpoint that you may have a right to do certain things, you may have a right to say certain things, but also law firms have a right to say they don't want to associate with you. And many of the students have been having their offers withdrawn based on some activities, or I know that there are federal judges that have said, I'm not going to hire law clerks that shout people down, that shout other people's speech down because they don't want to hear it and they don't want to follow the law and appropriately protest it in ways that they're allowed to show their disagreement with it. So there are consequences, and I think we'll come back to you, Mr. Ferguson, in terms of, and maybe other people, we'll talk about the areas that you can get tripped up as an attorney, how you can get reported, how you can be sanctioned, any number of things that we can't be with you every day, and we can't, it's like when you send your children out in the world, you can tell them how to behave, but you can't make them behave. But on the other hand, we hope to talk about the nuances of civility, the sanctions that can happen, or the consequences that can result, and hopefully, I think as Mr. Ferguson said, what are other ways that we can resolve things that are short of going, the nuclear approach? Do we have to report someone to the bar? Are there ways to resolve a comment that someone made that maybe you found offensive, but doesn't necessarily arise to incivility, but it merits a discussion? How do we have those? So I think that I'm going to go to Mr. Rivera because of all the practice that you've done, and talk about, how you try to promote civility in your practice, but this incivility that you see, and how things have changed throughout the years, and what your approach is.
Thank you, Your Honor. It's interesting. I was listening to Mr. Ferguson and some of the comments he was making about law students, and you're contemplating civility. It kind of made me go back and think 40 plus years ago what it was like. And I can't think that, I really don't recall at any time having to think about civility. I remember thinking about, you have decorum, you have to be professional, you have to know what you're supposed to, the law, so when you make your arguments, it's coherent, everybody will understand it. But I don't remember ever having to worry about name calling or somebody else saying different things. And it's an interesting phenomenon how it's increased over the years. When I graduated from McGeorge in '78, before that I was a night student. How many night students we have, by the way? Okay, yay. So you can do it, and it'll work. I worked during law school, and I remember one of my jobs was working at the U.S. Attorney's Office as a third-year student. And I was very, very fortunate to work with Don Heller, who just recently passed away, but he was one of the great attorneys here in Sacramento. And I got to sit in a trial with him and Judge McBride, you remember Judge McBride, district court judge, and Cliff Tedman, well-known criminal defense attorney. His son is also was a defense attorney, and I believe is now a commissioner and doing that type of thing. And he's argued in the U.S. Supreme Court in the past. So I got to sit in a trial with them, and as contentious as the facts were, these two were ultimate professionals. They could disagree on facts, but the cross-examination was crisp, it was concise, to the point, and effective. And that's the one thing that stood out to me. And so when I became a lawyer and became at the public defender's office, that's how I always wanted to try to emulate what I did. So you don't have to spend 2 hours berating somebody on a cross-examination. You can get it done in 15 minutes if you know what you're doing and you put your mind to it without having to be uncivil. You can get the questions out, get the answers out, and be done. And growing up as a public defender, you had the other DAs that you would work with on a day-to-day basis. It never really behooved you to make an enemy of a DA because you're going to see him every day, and you have clients that you have to take care of, and you know, by making an enemy with a DA, well, maybe that means you're not going to get the best disposition that you can for your client, because realistically, over 90% of the cases resolve. You're only going to try a certain percentage of them that you can do. So when you're working, you have to make sure that you're honest with them, forthright. You can disagree on facts, and you can disagree on certain things, but there are ways of doing that and explaining your position without yelling, screaming, or just being downright uncivil. And I think the face-to-face interaction that we had in the time before made a difference, because it was a lot harder to be uncivil when you're sitting there talking to somebody than it is pounding out an email or hitting Instagram or doing those kinds of things. And I think that has a different tone to it. So in private practice, when I went in there 10 years afterwards, one of the things that I always did when I got a case, there's somebody, I didn't know who they were, especially when I first started in private practice. I didn't know who they were, so I got on the phone, called them up, said, I'm so-and-so, I'm gonna be handling this case. We don't know each other, but I wanna let you know this is kind of how I typically handle these things. If you need extensions, you're gonna get them as long as they're reasonable. We're not gonna fight about these things. I always tell them right up, I don't like to do discovery fights. That's a waste of time. It's a waste of my client's money, it's a waste of your time. There's no reason for us to do that, and there's no reason why we can't. And I can probably count in one hand the number of times I've had to file discovery motions, you know,
Well,
over the
would
last
you
40
say,
years.
one of the things that a lot of the lawyers tell me is that criminal law is a lot more civil than civil law. What would you say?
Well, I would say probably yes. And it's interesting because when you're, and this is back before having to write a letter every time you talk to somebody. You talk to the DA, you said, hey, let's do X, Y, and Z. Sure, it would happen. In civil, it wasn't always quite that way, and especially if you didn't know them and you didn't work with them on a daily basis. So you would always have to write something down, you know, and send something to confirm what the conversation was. And that, I always encourage people to do that, because one of the very first times I was in civil practice, I remember speaking to somebody on the phone. I thought we had an agreement on something. I didn't write a letter. Nobody did. And later on, I said, hey, I thought we were going to do X, Y, and Z. Oh, no, I didn't say that. I said, okay. Well, I blame myself on that one, but that's just how it goes. So you do that. If you do little things like that, and they don't have to be mean, they don't have to be nasty, but it just cites exactly what happened, you can get along.
Well, would you like say when someone, you know that someone said something and then they go back on their word, that would be unethical. Is that, would you say that's not civil as well? Or how would you compare those unethical and civil?
I would think that, to me, I classify that more as uncivil than unethical, because somebody can always have a different interpretation of what was said unless you wrote it down and you knew exactly what you talked about. So I'm not going to sit there and accuse somebody of being unethical just because I had an understanding of what it was. Maybe that person may have had a little different understanding. And it'd be incumbent, I think, on me to have put it down on paper to make sure that what the conversation was about. And I think that's, to me, that's how I would look at it. Maybe I'm giving somebody the benefit of the doubt, but I think that's what you really should do, as opposed to just flying off the handle and saying, oh, you're unethical or whatever it is. And I think that serves you well over the course of your career, because I think people then realize what you do during the course of your career, and that's the kind of person that you are when you practice. And generally, you're going to end up with a good reputation. You're going to find out you're going to get in fewer fights, fewer arguments, in terms of what you do. You know, even over the course of 40-plus years, there have been cases where that happens. But, you know, sometimes they're unavoidable. But that happens. But the point is, you really do the best to mitigate that uncivility, because it benefits your client, it benefits the courts. They don't want to be burdened by little motions that really should be worked out by two reasonable attorneys.
What about though, but some, you know, I hate to be the negative person here, but I am kind of a crepe hanger a little bit. I've caught lawyers lying. There are things that are mutually exclusive. Is a lie uncivil, or do you call them a liar, or how do you call that out when something like that happens? What do you see as the remedies to that?
I can't ever think of a time that I called somebody a liar. I can certainly say they might have been disingenuous. I can certainly say that they may have been incorrect in their assessment or their recollection. But
if you told me I was disingenuous, you would be calling me a liar. Would that be?
Well, that's a nicer way of putting it.
Yeah.
You know? But that does happen. You have seen it happen. If oftentimes you can have, there's probably something in the course of the case that you have that would dispel what that person had said, and then you could just use that, and then the court would be the one who's going to end up making that determination.
Well, when you mention the court, what role, from your perspective as a private practitioner, does the example of the court, the judge, what role do they play in maintaining civility in the practice of law?
Well, if you have to file certain motions, and mostly it's discovery, generally is where you see a lot of these, because there's a disagreement as to what should be released, not be released, and all that. That's generally where the courts can come in. I think the courts can have a pretty good idea, first of all, of most people who come in with discovery motions. You probably see the same person coming in 20 different times on a discovery motion, whereas somebody else who makes a discovery motion, you go, you know, I don't remember seeing this person making this motion for about 5 years. And you're wondering what's going on, because I know they're working. I know they have active cases. So I think the courts will understand at some point where the problem lies in terms of the people that come in there on a regular basis on motions such as that, in terms of those that don't.
From your perspective, and I'm going to talk to the judges about this, what role do you think sanctions need to play when things, in terms of civility?
I think sanctions do play a part. I think it's important. People who get sanctioned, depending on whatever the amount is, and we all know we have to report it to the state bar if you get one for over $1,000. It's significant, because then the bar's going to know who you are. They're going to take a look at it. The judges are going to know who you are, because they're going to know that you have been sanctioned certain times for various reasons, whether it's because you said something that was incorrect and you knew it was incorrect, whether it's because you're burdening the court unnecessarily because of some of the motions that you file. Whatever it is, they know. I think it's important. And I think the judges realize it's important, because I have seen an increase of the sanctions over maybe the last 10 years than I saw the first 20, 25.
Well, I'm going to kind of say a bad word, because you've done criminal law, so I'm going to put it in quotations. In criminal law, they say snitches are bitches, right? Unquote.
They have said that.
And so I mentioned the new snitch rule. How do you think that's going to, how does that strike you, or how do you think will that come into play with uncivil behavior? It talks about committing certain acts, but it does say things that go to integrity and things along those lines. How do you see yourself trying to get your arms around that? Does it concern you to have a rule like that?
That's an interesting question, because I reread that a couple of times today, and it seemed fairly clear that it was talking about conduct that could almost rise to the level of somebody directly lying, knowing that it's a lie, or somebody who's doing an act that's criminal, as opposed to doing something that is uncivil. Now, uncivil could mean, you know, I'm yelling at them, I'm not gonna agree, I'm gonna make you file a motion. To me, that's not something you're gonna snitch on. I don't see that. And probably because I did some criminal law and criminal defense, I'm not real keen about snitching on somebody. I just don't, that just doesn't seem the thing that another lawyer has to do, unless you see something that truly is an act that almost could be deemed criminal. It doesn't have to necessarily be that.
But there are hard elbows,
There are
litigation, and I could see that there would be people that, it does say in there, if you maliciously report someone, then that comes back to the person that's the malicious snitch. You gotta be a righteous snitch if you're gonna do it. But
Right.
by this same token, you know, if people if they start doing that regularly as the arrow in their quiver, could you see that as presenting difficulties?
Oh, that could be a real problem. I can already think of somebody that I had a case against, and not a local attorney, somebody from Los Angeles, that was like that. And it was, it seemed like we were back, and it was a federal case, so we were in front of a federal court judge regularly for various complaints. And I will tell you that, and most of them were directed at me, and which was fine. The judge read the record, determined that we did nothing wrong, and then said, you know, we're gonna conduct all discovery here in the courtroom, in the courthouse. We're gonna do it right in the jury room, and if there's a complaint, you call me right away. And amazing how things calmed down after that, you know, when that happened. But, so that will happen. You're gonna find people who are gonna be that way, and they're gonna complain about everything, right or wrong or indifferent.
Well, you sound like you'd be a pleasure to have in court, but not having had that pleasure, I'm going to move to Judge Flores. And Judge Flores, you're dealing with these issues. So tell us how incivility comes up in the context and how you deal with it and examples of it.
Thank you, Judge Callahan. Good evening to everyone. What a pleasure to be here tonight on this important topic. And it's not only important because McGeorge was wise enough to have this program, but it's obviously important because there's new laws coming out in the state. This so-called snitch rule for attorneys. Just today, there was an ethics opinion for judges about our responsibilities to report attorneys. And this is, I consider it a follow-up because the rule was already there, but it is further guidance that I interpret to say you can't just not report. You do have to take action from time to time. So that is an unfortunate state of the law, that this increase, there must be an increase, is my deduction, in incivility to get us to this point. And I can really echo a lot of what Mr. Rivera said about not having seen that here at McGeorge. I was here from 98 to 2001 while on campus, seeing it plenty in civil litigation, and then seeing it a lot less in criminal litigation when I worked as a criminal defense attorney. In my court, I try to be cognizant of the effect that the judge has on setting the tone in the courtroom. I am cognizant that how I treat people in the courtroom will be reflected back to me. And I do put a priority on letting people know that I do run a formal courtroom, that I expect people to treat each other with civility, to treat all witnesses with civility, to treat all jurors with civility, and I give them the benefit of the doubt that we're not going to have this conversation again. The way that I've seen it come up in court in front of me has been shocking over the last 9 years. There really have been some bad examples. You know, Your Honor, she's having a hissy fit. All right, that's not something I expect to hear in this generation. Not that it was acceptable before, because it should not have been. But I've heard that in court. I've heard interpreters, court reporters, what I meant to say, throw their hands up because someone just stated their name, but it was a name that was ethnic, Chinese ethnic name that the person was not familiar with. But the reaction was, you've done something wrong. You're saying something different, and I can't I can't deal with it right now. Having an attorney recently respond to an argument from opposing counsel, well, that's ridiculous. Well, that's not a legal argument, right? And one of the things that I would like to convey tonight is that this is not only about let's play nice for the sake of playing nice. It's better to play nice. No, it's smarter to play nice. You will be a better advocate if you play nice. The jury's watching. The judge is watching. Everyone wants to root for the good guy, right? That's just the way it is.
What about the good gal?
Thank you for calling me out on that. Yes. Thank you for calling me out on that. I totally accept that. But that is our human nature, right? If we see someone mistreat someone else, it makes us feel like that person might mistreat us next. And that makes us uncomfortable. So part of my role as a judge is to try to put people at ease by setting the tone that certain things won't be tolerated. But as advocates, part of your role is to put even your opposing counsel at ease, right? We have a lot of doubts about people. If you're a litigator, you have good reason to be concerned about what the other side might bring. They might bring all kinds of problems to you. But if you have an advocate like Mr. Rivera who introduces himself and goes out of his way to say, I'm a gracious person, I do things reasonably, right? It just puts you at ease, right? As a judge, I like to put the advocates at ease. Like, I don't tolerate any crosstalk in court. No one should talk over anyone else. But I promise you that you will have a chance to respond, and you'll have adequate time, right?
It sounds like you define civility. It can be obviously interrupting people. It could be all of those type of things. But it's also that it might be how someone looks at someone, or maybe they're kind of being subtly demeaning, or the titles that they use. And I saw people sort of shaking their hands. Is that necessarily incivility, or does incivility require more a specific intent? So when you see that kind of conduct, how do you deal with it, and can you manage that to bring them into the real world?
Thank you. I'm really glad that you asked that question from my perspective, right? And when I talk to mentees, I always tell them take a lot of different perspectives, right? You may not, what someone says may not resonate with you on one topic, but it may on another. So my response to that is implicit bias absolutely plays in to incivility. It's because you are affecting how other people are feeling, and whether you know it or not, that's what's happening. So it's a big part of it, whether it's intentional or not.
Well, I had an interesting situation yesterday, and I didn't even actually notice it. Apparently, one of the lawyers yesterday addressed the panel as you guys. And so many people, were bristling over it. And I, on the other hand, was so focused on what the legal issues are. So I guess sometimes we have to check out what the response is. I mean, when I have heard people say that sometimes before, and usually I'll just say, hey, you might want to say the panel or the judges or something like that. Or I've had throughout my career, I've had people call me honey, or, any number of things, and I've kind of nicely corrected people. But I didn't even hear you guys. But then I saw a lot of you there were like, probably. And when you saw sort of how aggressive the panel was, you're thinking like, oh, the end of the world is about to occur here. And it went right over our head. We didn't even notice it. So I guess, do you have those discussions? Do you have litigants, or do you have attorneys bringing up saying, I don't really like how they're referring to me, or I think that this is demeaning? Or sometimes do you find that you have people that have paper thin skin, and being a litigator, you gotta be a little tough, right?
I haven't experienced that last example. But I have had people bring to my attention that something was happening that they didn't appreciate. And I was glad. I was glad that someone felt comfortable enough to bring it to my attention so that we could address it instead of allowing it to fester. I did want to comment, if I can, on the issue of sanctions.
Yes,
from,
please.
From the judge's standpoint. So I do feel that it's my job to impose discipline by the way of sanctions when it's warranted. Oftentimes, just awarding attorney's fees for the work that was needed is enough. And one thing that wasn't mentioned that I wanted to add is the attorney that's getting those sanctions, you're gonna have to go back to the office and talk to either your client or members of your law firm about why you're gonna eat those sanctions as opposed to actually passing it along to the client. So again, even if you're only concerned about yourself, it's better to be civil.
I want to ask you one more question before I go to Justice Bulwer-Uri, and because I know she's going to comment on this. Does civility manifest or incivility manifest itself in the written documents that you receive as well? Is it not only how people, but the vomit that comes out of their mouth and saying things that are inappropriate, or the implicit bias, but do you see things in the paperwork that, you know, I always think back on the Saturday Night Live skit where someone disagreed and then he would go back and go, "Jane, you ignorant slut," because they were trying to do, you know, that you see some of that going back and forth.
I've definitely seen incivility in writing, and it seems that sometimes the guard is dropped so much where so many of us communicate in writing via text message or social media that sometimes I have read briefs that I felt that it looked like someone was texting and they were just sending a message to a friend as opposed to a legal brief. So
Does that like make you automatically think, oh gosh, I want to read this brief and I bet they're really saying important things, or do you think like,
Quite
my
the opposite.
skepticism is up?
Quite the opposite. It takes extra work for me to check my bias about the form and to still look for content, but that's extra work, right? And as advocates, you want to present a packet to me so I could say, yes, what she said, right? Like, I want to use your language and put that into my order and maybe even repeat it from the bench. So the better work you do, the more civilized the work product. Obviously, the quality of the work product itself substantively is important as well. But we're all human, and how we receive that information will, at some level, play into how it is that we value its content.
Would you agree that sometimes, I mean, cases are hard, and sometimes the tie goes to the runner, and if you want the benefit of the doubt, how you behave over a period of time may determine whether you get the benefit of the doubt or not?
Unequivocally. I can say that when it comes to discovery motions and this type of attorney bickering, sometimes the first thing I read are the exhibits. I want to see how you talk to each other in emails. Like, that's going to set the tone for me. I'll spend more time on the exhibits than the actual brief, put it that way. Yeah.
Well, thank you. I'm going to go to the appellate court now. We go, that grades our papers. And so Justice Bulwer-Uri, if you could, you've had both a lengthy tenure on the trial court, so you're well seasoned that way, and you appeared as a trial lawyer, and now you're grading the papers of the trial courts, and you're seeing the advocates in oral argument. How do you compare civility in the appellate court, and what are the things where you find incivility?
Thank you, Judge Callahan. First, I want to say thank you to the Dean and thank you to McGeorge School of Law for having this conversation. I think it's really important for the practitioners, old and new, but it's most important for the students. To answer Judge Callahan's question, I wanted to go back and start with what Mr. Ferguson said. And he talked about some of the stress or some of the things that students are dealing with. And he mentioned that word, stress. In the trial court, you have zealous advocacy. You have high-paced calendars. You have lots of clients demanding your time, and you are appearing in 5 different departments within a span of 45 minutes, trying to articulate to the next judge why you were late. In the appellate practice, by its nature, there's more time to reflect. By its nature, you don't necessarily or even typically have your clients coming with you when you appear before the court. So I think the incivility that we see in the appellate practice, and Judge Callahan knows this well, is in the written paperwork. more often than not, the incivility that I see is the zealous advocacy in talking about how and or why the trial court was wrong. And some of the disparaging characteristics that are utilized in describing the trial court's ruling, I find astounding.
Ouch.
It becomes personal. Instead of just focusing on the legal issue and how or why the judge may have interpreted that particular issue, provision, statute.
Well, and you've been a trial judge, and you've seen some of those things. And just because someone disagrees, and more often than not, the court might affirm that trial judge, but to disparage and their reputation as that, you know, that they didn't read things, or they don't understand things, or that they were, you know, that it does kind of raise the bristles. And I think, as Judge Flores was saying, it's like we can accept that people don't agree with us, but that doesn't mean that we're stupid because we didn't rule in someone's favor.
That's true. And go ahead, we're pivoting. We're flexible. This is what happens in the trial court. There you go.
There you go.
So one of the things I also wanted to pick up on was Mr. Rivera's comment about reputation and how your reputation grows over time. To all of our students in the room, please know your reputation starts now. Please know your reputation started the day you set foot on this campus. This is a small legal community. Should you choose to stay here in the Sacramento area, it is a small community with a long memory. You may be opposing a colleague, a student, a peer that you were pretty nasty with on one particular day. And lo and behold, 3 years later, they're opposing counsel, or you're appearing before them. Please understand, your reputation starts now. Judge Flores talked about it's smarter to play nice, and I agree with him, but I'm going to take it one step further. It's smarter to play nice. It's better to be nice. It takes work. As professionals, you're not required to be perfect, but you are required to be your best at all times. Judge Callahan started us off tonight talking about and reading the oath, which says at all times. That means, are you the same civil person that you are in the courtroom, as you are at the gas station, as you are at Home Depot? I'm not saying be perfect. I'm saying, to Judge Callahan's comment about whether or not civility requires specific intent, I think on some level it does. You have to be intentional as up-and-coming lawyers. You have to be intentional with what you say. You have to be intentional about what you do. You have to be intentional in your interactions. That doesn't mean we don't get frustrated. That doesn't mean that we don't have different points of view. But in my mind, to be civil is that very word. Be that way. Be your best person. It's hard. We all fail. I fail. Some days are better than others. But as a profession, everyone needs to understand, and the lawyers and judges in the room know, you have such an awesome power in this society. I think the fact that we're talking about the snitch rule is more a function of where we're at as a profession versus the OG time when the profession was policing itself and that wasn't going to be tolerated. So I want to just encourage your students. I think civility is not just about tone of voice. It is intentional, and it takes work, and it's necessary and what you're required to do.
I think, too, and maybe I'll kind of throw this out to the panel members before I come back to Mr. Ferguson and go to the audience, that we've all had the situation where someone contacts us and say, you know, you offended me. And it's sometimes you're just completely, you had no idea. I mean, it completely comes out of, so, I mean, I've had situations where someone has either misheard what I said or I meant it another way. But I think on a very basic level, I can't make everyone happy, but I don't really want to offend people. And if someone says I offended them, I have to take a breath, listen to what they say, and decide, at a minimum, if I apologize, I'm sorry that I offended you. That was not my intention. Here was my intention. Now, we may not agree here, but I don't choose to I don't choose to offend people. That's not my first attack. And I think we've talked about in litigation, and, you know, I look back when I became a judge, I immediately decided that, oh, I'd been such an annoying lawyer when lawyers started appearing in front of me, and then I saw some things that I did, and I thought, oh, I immediately apologized to one judge and said, oh, that I tried a lot of cases. I said, I'm so sorry. And he said, well, you weren't that bad. But I was very, aggressive I was a very aggressive trial lawyer. And I think I said it yesterday, show me a good loser and I'll show you a loser. I didn't like to lose. That doesn't mean that I wanted to be uncivil or that I certainly didn't want to be unethical. But sometimes in your zealousness, that it can go maybe just a little further than you need to. So, Mr. Ferguson, if we come back to you, how are you feeling now? Are you excited to be practicing?
Oh yeah, I think I have great mentors, and taking after what Mr. Riviera said about just really being a gracious person and being reasonable. I have a lot of that from my mentors, but to take what you said, Judge Callahan, and the point you said about really, you have essentially a duty to mitigate as opposing counsel, at least their offenses, their emotions, or things of that nature that may rise to the level of incivility. I think we can take that and start that at the law school level, in that where you may feel offended and it was unintentional, but as someone who has felt offended by words of another student or of a professor, taking that duty to either try to mitigate that or reaching out in the sense that it does not lead to incivility, to understand why words were said. And I think that the stress that comes with law school doesn't allow that to happen or kind of blinds that. But I think a decent approach and the benefit, or one of the great things about academia and law school, is that we are all understanding and we are teachable. And I think in our Unity Caucus meeting, or in our meetings, our prep meetings, we mentioned how if there was a instance where a professor made a comment or read from the script or read from a text, read from statute, et cetera, something that was offensive, one of the things that we can do to engage in DEI work, or to have the professor understand why the student may have been offended as a result of their comments, is to try to engage it from their perspective. And I said, all professors are mostly nerds, and we're all nerds. We're in higher ed. We went to law school for extra 3 years to, learn more about the law and legal writing. And as such, how about we engage in them to engage in a research study that allows them to see from a different perspective? And that I said I love Professor Vitello and I love Professor Salcido for their classes because they incorporated. I think day one or week one, we learned about Emmett Till and the use of jury nullification. As a young black man, that interested me. So, okay, how can we incorporate more of that? And I'm sure Professor Vitello, via his background or via research, thought that that was an important juxtaposition to say, okay, well, here's how jury nullification can be positive, but here's also how it can be negative, citing the DC circuits or the DC district courts, in which a lot of the petty drug cases are often the jury just says no because we don't want to see any more black men or women incarcerated. Wherein the jury in Emmett Till's case just said no because it was a jury pool of white men who saw their peers as not wanting to go to jail. Professor Salcido, of course, we touched on redlining a lot and property law. So incorporating these perspectives and having professors do research can influence that perspective such that when it comes time to either understanding or being preventative as it relates to a student's offenses or what may offend a student, they can see that and be, empathetic or sympathetic of that as the time approaches. But that is a duty to mitigate that you mentioned, that I think it really is not only on the professors, but also us as students when we feel offended from someone who may be a conservative or a liberal, someone who doesn't identify with something that we fundamentally disagree, that we may feel offense to. We incorporate to either reach out or try to understand, not from a malicious perspective, but from just a general point of understanding as to what influenced you and what influences you to make that statement or to believe that thought. And I think that's something that's important to us, that we can start in law school that can translate well into practicing attorneys and judges on the bench.
I think an area that kind of exemplifies this, and I think people can say, there's a big debate about peremptory challenges for cause. The whole Wheeler-Batson challenge, has changed as far as that goes in California. And I would say, and this I'm going to say as the truth of having lived in a courtroom for many years, having done 70 jury trials as a lawyer, and doing back-to-back jury trials for 4.5 years as a Superior Court judge and continuing, jurors are not necessarily aware of their bias many times. And it comes in all, and we, a lot of times as humans, don't see our own biases. You know, we're not good at seeing those. And I think in having these discussions, it's important if you listen to what the other person says and what they heard and what you heard, and accept the fact that all of us, in certain instances, probably would not be a good judge or a good juror as far as that goes, because we have had life experiences that cause us. I mean, you mentioned that you have certain perspectives growing up as a black male and looking at certain things that way. There are people that probably in courts have had different experiences with jurors of different ethnicity. I've noticed that certain ethnicities will convict other ethnicities pretty fast, and that it's more complicated than people want to say. We are more complicated. And I don't know if anyone on the panel wants to comment on that. And I think recognizing that about people, about ourselves, that these situations always don't have an easy answer.
Well, I can say, and picking a jury and just trying to get a sense of what that person was like, you have to listen and ask some questions. And I wouldn't necessarily ask a question about the case. I'd ask questions about the person to get a sense of what that person was like. And you get a response, and then you can you should be able to tell if that's somebody that's going to listen to what's going on and then make a reasonable determination, or is it going to be somebody that's not going to be that way? And you can do that.
But it's harder than people think, because a lot of people get called in and they've never been asked to say if someone's guilty or not guilty of murder. And I know as a judge, when I've had court trials, I thought this job was pretty easy, and I was pretty critical of a lot of judges doing it. And I suddenly got there and I thought, good judges make this look a little easier.
Absolutely.
And it is hard. They're hard jobs that we all have.
No, and you're right about that. And I don't know that you can tell whether somebody's going to have an easy time making a decision or not. Maybe sometimes you can, depending on how they respond. You know, because I mean, some people say, I could never say somebody's guilty. Like, you know, I just don't want to put anybody in jail. Okay, that's fine. And that's at least that's an honest response, hopefully, as opposed to just want to get off the panel. But you do get a sense in talking to somebody and what they're thinking, what maybe their line of thinking could be as to whether or not that they would be a reasonable person for the jury. You're not going to get a perfect one. You never will.
And people could have prejudices, but it doesn't mean they're prejudiced in all aspects, or that they're not bad people, or that they can be educated. I want to give everyone a chance to ask us my wonderful panel, some questions. So do we have any, do we need a mic to take out further questions? Or, we have Vanna White here coming and turning the letters here.
All
So
prepared.
raise your hand if we have a question in the back, and then Mr. Blanco in the front.
Good evening, thank you. I'm intrigued to hear about this notion of civility coming from a field that's until very recently been almost exclusively white male. And the systems of toxic masculinity and of white supremacy culture that are baked into the notion of how we all were raised and brought up looking at the legal profession. Attorneys on TV and in the media are loud and they're brash, and they like to trick people into saying things and something almost the opposite of appearance today. So I'm fascinated, first of all, that a panel doesn't include white men, which is fantastic. Where these things play, is this lack of civility a demonstration of what we've come to expect, or is it something new?
Jesse, I see your mouth moving.
I think I can say something about that. It's interesting. I was thinking the same thing actually when you get here and you say, no white male here. In 1978, when I started, there was one Hispanic, one Latino judge here in Sacramento. Trying to think how many female Superior Court judges there were, and I'm not sure that I can think of one at the moment. Maybe one. Yeah, that's right, Judge Miller. And we had William Morgan, Tom Doherty, who were both African American, Judge Sakuma, who was Asian, and that's it. And so, you know, you walk into a courtroom and pretty much you have a white male up there, and they look at you a little askance because you're a young Latino coming in representing the criminal defendants, and you're not going to get the benefit of the doubt. That's just not going to happen. But the way you did is by being professional and being ready, being prepared, knowing how to answer the question when the judge would ask you a question and giving them the right answer. And I can tell you that, and you know, maybe it's not overt, it's going to be implicit. You're going to get this implicit bias when you walk in and you see a judge and they're talking to you and you go, this guy doesn't like me very much, but that's okay. We're going to figure this out. Over the course of being in that courtroom, maybe 3 months or 4 months, pretty soon that judge would see how you acted, how professional you were, how prepared you were. You got the benefit of the doubt, which meant your client got the benefit of the doubt. It worked then. When obviously there was clear biases going on. It will work now. Always be professional, always be civil, be prepared.
Well, I want to give a little plug for white men, though, too, because I'm where I am because of a couple of white men. Because when I wanted to be a judge, I didn't know anyone, and the people that were in power were white men that chose to support me full-heartedly and gave me wind beneath my wings to go forward. I think in law schools, now we have more women than men. I have law clerks that come from very diverse backgrounds, and some of my hardest ones to find work are white men because they can't check a box. And so I'm gonna say, I look at diversity more broadly, and I think we all bring something to the party. Yeah, and I say this to people, you know, what is your je ne sais quoi? What do you contribute that's different than anyone else? How are you diverse, and how will you make this more interesting and more involved? So I think we really have to, I've seen good in all places, but I think Jesse's right in the sense that if you've been undervalued, if you've been underestimated, if you've been marginalized, which I felt like I was as a young trial lawyer, and my response was, well, I'm gonna kick your ass. And when I win, then you're gonna remember me, but you're not gonna see me coming. So you always have to be flexible in the world and see what's in front of you and figure out, and address things when they're wrong, but you also have to be a person of substance. Mr. Blanco. Go ahead.
Thank you very much, Your Honor. I feel it's an honor to be here and with these four awesome panel. My question to one of you is, in your opinion, how has the racial inequality protests that occurred in 2020, in what way has it impacted, or in other words, polarized the legal profession?
I'll take it to start. So when we had the George Floyd protests, many of you in this room will know, will have seen, will have read our former Chief Justice, Tani Cantil-Sakaui, put out a statement on behalf of our California Supreme Court, attesting to, saying all the things that we know we want our leaders to think. But by that brave act, she called upon and tasked all of the courts around California to talk about inclusivity, to talk about what are the ways that we are not appreciating who walks in our doors, and how do we do a better job of understanding those challenges. So my response to your question, which I think is a fabulous one, is that it impacted the branch, it impacted the judiciary by our true supreme leader, my forever Chief Justice, love Chief Justice Guerrero, don't get me bound, but really calling out the strife that everyone saw and felt and many participated in, and said the judiciary has a place in this dialogue, and the judiciary has a place to make things better, to make access more equal, and tasked us to do that, and I think that we have done that. We're not there yet, but we continue that work.
Well, and don't you think, all the judges that I know pretty much uniformly really want people to have faith in the system. We really want to create access to justice, and but but we have to learn along the way too.
That's right.
And as Justice Bollier-Urey said, you know, we have to respond to things. We have to be flexible. We have to, you know, we have to be of the times. We can't be, oh geez. You know, we have to go with what's expected. The law changes. But at heart, I can honestly say, working with a lot of judges, I really feel the vast majority want people to feel heard. They don't, but there's a learning curve, and some do it better than others, and training is something that is very much involved in the judiciary. I know that Justice Bollier-Urey is involved in training. I do. I know Judge Flores, you know, all of us are very active in training. I think we might have time for one more question.
Can I address
You certainly can.
the last ones? So I did want to point out that from my perspective, the issue of race, ethnicity, gender bias, that's not the only way that incivility comes up. So that may be part of what was talked about here. To me, it's a lack of respect for another human being that is at the core of it. Those are just examples of how people disrespect each other. Intellectual, perceived intellectual capacity, perceived prestige because you're from one law firm or another law firm, or you represent X or Y clients on an appointed basis or a retained basis. All of those things have a negative effect on our profession. And we all have to be cognizant of that. I did want to add to the issue of racial justice. I also felt very proud to see our Chief Justice put out that statement and to reemphasize what some of us who are already sitting as judges felt, that we needed to have a broader conversation with our colleagues. Some that may have more experiences, direct experiences with respect to racial issues, personally or vicariously, and others that had less. People don't know what they don't know. And it doesn't mean they're bad people. They just may not appreciate how their actions can have a negative effect on certain things. So part of my push, aside from being involved, we created a book club where judges got together and read. We've read like 7 books on racial, economic racial issues, an environmental racial issue, the new Jim Crow. I can give you the whole list. But that was impactful. I learned in that situation, I was the only one that was part of the book club who had ever been robbed, right? And it was like a big deal. And coming out of high school, I didn't know any of my friends who had not been robbed at some point, right? So these are the types of life experiences that you can share when someone opens up the conversation for the dialogue and gives it space to happen. And that's when we realize how little we know about different things, including myself learning a lot because we covered a whole lot of topics. Thank you.
So I think we have to bring this to a close, but what all of you have said brings to mind a quote from a very famous poet laureate, Maya Angelou. She said, "People will forget what you do, they'll forget what you say, but they'll never forget how you made them feel." So thank you for joining us, and please give us a hand, give a hand to my panel.
Thank you, guys. Thank you.
So there's just a smidge of ceremonial part left because we have gifts to give to each of our panelists and our moderator. And I'm going to take advantage of that moment to just add one tiny little thought about each of them. First off, to Judge Callahan, who, in my experience, is all about service, and really all of us can aspire to how much she has chosen to give to her community, to the legal community, to fellow lawyers, to fellow judges. I know I sound a little bit like a hero worshiper, but you'll just have to live with that.
I'm all about that.
And these are all labeled by name. So, and I'm sorry, Justice Bulwer-Uri, they have McGeorge swag in here. Next up is Khalil Ferguson. I'm going to tell you a Khalil Ferguson story. So, it's almost about 2 years ago. He reaches out to me. He's not yet a McGeorge student, and he wants to have coffee with me. And I'm thinking, well, prospective student might want to have coffee. Okay, that sounds really good. I only realized afterwards that he was interviewing me to see if I was good enough to be his dean. And now I know that I'm the chief nerd. So as always, I learned from Khalil, and I actually have expressly learned from him because he was kind enough to share a book that he had written with me. He shared the book with me that he had written. So Khalil.
There you go.
So I decided I was kind of hoping Jesse would be on this panel when I started running into him constantly in the community. There was a really terrible time for him where we would go to every single event and we would both be there, and he would try to run away and I'd try to run up to him to talk to him. And he was always just so incredibly gracious, as you saw, and thoughtful, and really did emulate what I think we want to see in practitioners.
Thank you.
I am just checking the names just to make sure it comes out right. I met Judge Floreszen now a few years ago, I think in the Zoom era, actually, and he served as a panel. And one of the great things about a panelist for us with prospective students, and one of the great things about him is he didn't just serve as panelists. He also said, well, there are 2 other McGeorge alumni judges in the Bay Area that I think you should put on the panel with me. And so we ended up having this incredible panel because he is a person that is so connected. And so, if you ask me, how do we end up with these panelists, at least from my perspective, I thought, oh, people I like listening to. And so that's really what I loved listening to him when he was on that panel for prospective students, and I loved listening to him again. As you know, I'm like all McGeorge all the time. I'm like a ridiculously pro McGeorge human being. So that means that Justice Bulwer-Uri has to be friggin' brilliant for me to desperately want her to be on this panel. And I think you heard that tonight. There were moments where I felt actually mesmerized by her comments. Thank you, Justice Bulwer-Uri. And there's that extra bonus for each of the panelists that they get to be hugged by Judge Callahan. Exactly. So thank you all for being here tonight. There's probably a little bit of food and beverage left. And please join me again in thanking our moderator and the panelists.